you can vote for your government, and until December last year, you could even get married by the time you turn 18. Once you reach this age, you're empowered to make independent sexual choices. In simple words, you are empowered to give consent. Let me tell you what the current law says about consent and age. If you're under 18 years of age, your consent does not count in court. Any sexual relationship you engage in is considered statutory rape. Your sexual partner can be charged with child sexual abuse. Now, if you're over the age of 18, if you're 18 or above, your consent does count in court. Why am I talking about all of this now? Well, because the Karnataka High Court has opened up an old debate. It wants the Law Commission of India to review the age of consent, possibly reduce it from 16 to 18. The question is, why? Honestly, because times are changing. More and more teenagers engage in sexual intercourses before turning 18. But under the eyes of law, those relationships are illegal. They constitute rape. The court has noted that in recent times, this is the Karnataka High Court, in recent times, it has encountered a number of cases where young love has turned sour and led to false charges. Not just any false charges, but fake assault charges. How do you navigate this problem? It's a complicated one. Let's take a look at examples from elsewhere. The age of consent around the world ranges from 11 to 21 years. 11 in Nigeria, which simply doesn't make any sense, and 21 in Bahrain, which again doesn't make much sense. Most countries fall in the bracket of 16 to 18 or thereabouts. In France, the government uses something called the Romeo and Juliet clause. Their official age of consent is 15, but if the relationship is consensual, it will not be considered rape. So is it time for the POCSO Act with the Romeo-Juliet clause as well? Australia. How does Australia tackle that problem? Well, it tackles that problem through awareness programs. Consent classes are mandatory in the country, meaning children are taught about good and bad touches, age-appropriate relationships, coercion, and power imbalances. They essentially prepare teenagers for real-world situations. But is something like that practical in India, or would it dilute the POSCO Act and make it easier for predators to escape justice? That is what I'm asking my guests who are joining me this evening. Lalita Kumara Mangalam joins us. She's a former NCW chief. Talish Ray is an advocate. Deepika Bhardwaj is an activist. She's also a documentary filmmaker. And Abha Singh is an advocate. I know opinion is divided on this one, but Lalita ji, I'm going to start with you first. Take a look at the case that the Karnataka High Court was looking at. The case dates back to 2017. This is where a young couple is in love. The girl is 17 years old. Their parents get a whiff of the relationship. They go complain. The boy gets punished. No, I believe he's let off by the court. Then the government goes to the Karnataka High Court and said, look, this is what has been done. And today, that is the case that the Karnataka High Court was dealing. From 2017 to now, what has happened, Lalita ji? The two people in question, the girl and boy in question, have got married. And they have had 2 children as well. I want to ask you where you stand on the debate on age of consent. Is it time for us, given our changing times, to reduce it to 16?
Quite frankly, I don't think we should reduce it to 16. But I do agree that if we don't, especially if we don't decrease the age, we need to bring in certain changes in the law. The reason that I'm afraid that, if decreasing it from 18 to 16 may put a lot of other young girls, rape has become so unfortunately too common in this country. And this clause could be used against girls between the ages of 16 and 18. Could be. I'm not saying it will be, but it could be. That's the main reason for my hesitating to say that, yes, bring the age down. What I would rather say and rather see the state or the court do is to make classes, what you call consent classes, which is being done in Australia, to make it necessary, compulsory for schools to teach children what safe sex means and what good touch, bad touch means. I think good touch, bad touch today is taught. And I agree that the age of first sex in India has dropped to 13 amongst girls. This was a few years ago. This is not just today. So young children are having sex, and it's almost impossible to police them and ensure that nobody will ever have sex, regardless of whether we accept it, regard it as wrong, right, etc. All that is a totally different argument. Let us look at it from a purely practical point of view. I think that there should be something in the law where the court should be able to check whether it was, two young lovers have taken their relationship to the physical level or not. Now, I also know that there will be a huge outcry where they say that women will misuse the law, which has often been said about both the POSCO, the Prevention of Sexual Harassment, and the rape law, especially when it comes to minors. But the point is that, all of India is also not urban. We are talking about the age of first sex more to do with urban cities, Bombay, Chennai, Delhi, Hyderabad, Bangalore, Trivandrum, etc., etc. In the rural areas, even now, girls and young boys, more girls than boys, we unfortunately are still a very patriarchal country, much more strictly policed. And if anybody comes to know that a girl, who's unmarried is having sex, what happens? Now, again, that's a different debate. I have very strong views on that. I'm not going into that here. My only hesitation or my only apprehension is that if the POCSO Act says that 16 can be the age of consent, then you may have a lot of rapes where we are told that, no, the girl actually said yes, but now she's turning it around because she's afraid pressure has been put on her. And that may not be true. However, what I said, that we need to teach our youngsters what safe sex means. And I'm willing to argue this really strongly because a lot of people will not agree with me. I also feel that we must teach
for the moment, Lalita ji, there is a lot we need to teach our young people. But I think essentially you're not taking a stand on this one. You're not. Just so that I clearly understand the position that you're articulating. You're saying while looking at the. As of now, Deepika Bhardwaj, do you buy the arguments that Lalita ji is saying? Given the realities of India, maybe now is not the time to reduce the age of consent. France is different, Australia is different. Right now in India, let us stick to 18 and not reduce it to 16 because it will make a lot of girls very vulnerable.
I disagree with what Lalita ma'am said, Shreya, and I think I have a very strong opinion on this subject particularly. And this is not just my opinion. Data, there are a lot of researches that have been done. One that I would like to quote is by Rukmini S. of The Hindu. She had actually gone through 600 cases almost one by one, assessing each, following the cases from the beginning till the trial. And it was found that almost a quarter of cases, 1/4 of the cases were the cases where there were elopement of couples. These were consensual affairs. And then the man was charged of rape by the girl's family and girl's parents. And what is really bothering here in a lot of majority of such cases, Shreya, is that the boy who gets charged is a lot of times that boy is also a minor. So, you are actually turning consensual sex into rape. I do not think that should happen. And I'm strongly in favor that the age of consent should be reduced to 16 because let's be conscious of the fact that teenagers these days have a lot of sexual content at their disposal and they do experiment with sex, and converting consensual sexual affairs into rape and then turning the boy a rapist when all that they were doing was having being in love with each other. So I think this is a great move by Karnataka High Court, and let us also understand that they have asked the law commission to look into this. And that, I think, is the best approach whenever we are dealing with laws. The law commission can actually do a thorough research, look at the cases that are landing up in court, and let's be conscious of the fact also that cases where it is not rape are, going to the courts and clogging the system, where it is actual, genuine victims of rape that should get the time. And we, of course, have limited recourses.
But there is a flip side too. I know that, in many circumstances, the law has been unfair to boys. even those who are minor, because things have happened, a consensual relationship has gone sour, and then charges of rape, or if parents find out charges of rape, that has simply been unfair. So yes, there has been a certain misuse as well. But Talishree, you're an advocate. As an advocate, help me understand, where is the problem if the POCSO Act recognizes what French called the Romeo-Juliet clause, that young people do fall in love, they do have a consensual physical relationship. You need to take that into account whenever cases like this come to you, because the Karnataka High Court, for example, wasn't talking through thin air. They have said that they have come across many such cases. In the case that they were particularly dealing with, the young man is, accused of rape under the law. Turns out it was consensual. The two have now gotten married and have 2 children as well. And the case since 2017 has dragged on, if you please.
Yeah, so Shreya, a couple of things that you must keep in mind. When we had the POCSO Act, which is the Protection of Children Against Sexual Offences Act 2012 that was passed, that was essentially passed in order to protect children against any manner of sexual offence, which is very rampant and prevalent, right? But currently we also have a situation, and we must talk about the various kinds of Indias that we have. There are some where teenagers in urban centres and urbanized places are at an exploratory stage, and consensual relationships. And as you said, consent itself under POCSO is not recognized if it is for somebody under 18. So how is it that when we look at, say, suppose the opposite side, which is being accused, which is typically a man, being accused, and that young person who might be under 18, who may identify with the gender of being male, how is it that an act which is supposed to protect children actually became draconian towards them? And I think that therefore it becomes important that one doesn't have to really look at it in terms of lowering the age as well, because there is fair bit of merit that this came about, and the definition of children as it has been set has been done after a lot of thought before this law came in. But what needs to be looked at is that whether, if both the parties are of similar age, whether their consent would be considered. Because again, let's keep in mind that there are predators around. There is a huge amount of crime that takes place against children. So I would actually be looking at more if the offender is of a similar age, then do we look at consent? Exception needs to be carved out. There's definitely a need for that exception, but it can't be generic in terms of reducing the age itself. Because there is certain merit to the fact that at the age of 18, there is a greater development in terms of understanding of consent. And then the second thing that the Bangalore High Court has very wisely pointed out, which is, repeated trainings that need to take place. Now, most educational institutions in super cities as well as class 1 urban centers do have this kind of training, but there is a need for more rigor for them to understand realities around POCSO, to understand consent. But at the same time, because teenagers considerably with the kind of exposure are more exploratory, as our society also embraces values where we encourage them to be open, it is important that we look at the age of the offender and look at the consent aspect only if the offender's age is also in the same limit. Otherwise, what is the point for a law that came about for protecting children becomes draconian against
one is
child?
Not saying, absolutely, one is not saying that if the age of the girl is 17 and the age of the man is 40, you try and look, you try and look at the whole angle of consent. Absolutely not. But we need to be rational about it. Unfortunately, the law is the law, and law enforcement agencies go by the law. So if the boy is 17 and the girl is 17, the 17-year-old will be hauled up and put behind bars. It's as simple as that. The law does not make concessions. Is it time for them to do it? Abha Singh, it's interesting then that since 2017, anyone under the age of 18, anyone having a relationship, that relationship is illicit even till today. I mean, as we speak, any 17-year-old or 16-year-old in a relationship, a consensual relationship, essentially is indulging in something that is illegal.
Absolutely, but the biggest issue here is consent. How was consent given? It was under duress. But if it is as per the age of consent under 18, then even if it is given voluntarily, then also it is an offence. Now, if you go by Section 6 of the POSCO Act, it says whoever does the penetrative aggravated sexual assault on a child below 18, a girl below 18, it is punishment is for not less than 20 years, and it can be also life imprisonment. So this is the catch, and rightly so Bangalore High Court when it says that if the age is to be looked into, 17, if the girl girl is 17 and the boy is also 17, then there has to be an exception. Because I have visited so many POSCO matters in Dongri special shelter home, and there these children, 17, 16-year-olds, which whom I call, you said Romeo Juliet, and I say teenage love affairs gone sour, because these girls elope with these boys. That means their classmates, they elope, but under the parents' pressure, the girl comes back and then she puts a case of rape. And then these young children, school-going kids, are there undergoing punishment, and they are harassed, sexually assaulted, bullied, because they come with a stigma called rape. So it is definitely the time to look into this fact, because you cannot have tender age because just because your age of consent is 18. So yes, between 16 to 18, if there is a sexual relationship and it is consensual, if they are class students, if they are friends, that needs to be looked into, and an exception needs to be made under the law, because Bangalore High Court was looking under 376 2J, which again says that if you have a relationship with a woman who's less than 18, then it is rape. So, and now in time, today's time, when we are following the Western world, when we are very open about these things, and children are indulging in sexual relationship from the age of 14, 15, so we need to revisit the law, which is very true.
You know, and everyone's talking about the rural-urban divide, about there being different Indias. Yeah, there are different Indias, but teenagers are teenagers all across the world. And given the access to social media that everyone has, most teenagers across this country are on the same place. Same plane. Deepika and Bhardwaj, come in here. Look, the Law Commission of India will look into the matter, and they will decide what they decide. Do I think that they are going to lower the age of consent to 16? Perhaps not, but maybe they will have a Romeo-Juliet type clause in. I want to ask you, for a government that has actually increased the age of marriage for young girls from 18 to 21, does one really practically think that they will actually lower the age of consent? I don't think so. There is a certain morality, a certain question of morality also that seems to be, you know, that seems to be ingrained in this debate.
Shreya, I personally feel that I think it's at the end of the day what Law Commission will, you know, recommend to the government, it will then have to be taken up by the government. But yes, I completely understand that there are a lot of there's a lot of morality that comes into this into the picture in these cases. But at the same time, I think it is you know, one of the panelists earlier said that as well. It is very important to look that, you know, what kind of boys or what kind of human beings are you actually criminalizing? I mean, I feel really, really bad for these young boys. They would have never thought that, you know, something as heinous as rape, they'll be charged of that, and then their whole lives get destroyed. So I think there is a need. The government will definitely have to look at the, you know, the realities of society. And one thing also that I wanted to add was that this urban and, you know, rural divide, I personally have seen so many cases coming out from, you know, small towns in small villages also, where there's elopement is actually happening a lot over there. So I think the government will have to look into the ground realities and accordingly amend the law, because they have to understand that it's a very serious charge, and no innocent should actually be accused if they have not committed the crime.
Absolutely. But Lalita ji, you were saying no to something that I said. I was talking about whether there is an element of morality that is also ingrained into the POCSO Act, with the age of consent being 18 and not 16. You wanted to come in here. My entire point was that, you know, in India, recently, last December, in fact, the age of marriage for a girl has been increased to 21 years old, 21 years. That itself is, you know, that itself has its merits. There's an argument for it. But how does it tie with us having this debate of actually lowering the age of consent then as far as sexual activity is concerned?
At all. The primary reason for increasing the age of marriage from 18 to 21 was that a lot of young girls who want to continue to study, who may have, you know, actually an opportunity to study or get trained or skilled and move forward in life to become more empowered, it's better for them not to get, I mean, 18 is really no age to be married. Come on, all the five of us sitting on this panel will agree. At 18, you're still really a child. Having sex with somebody, experimenting with physical sex is totally different from getting married. I think we all will agree on that. That is the reason that I also at that point of time had said that the age of marriage should be increased from 18 to 21. Now, most young women, and there is enough data to support this. That's a different argument a different debate for a different day. But the fact is that had nothing really to do with morality. This case where you say that, yes, young girls shouldn't have sex, etc., etc., I agree. We live in a very patriarchal society. And, there will be a lot of pressure saying that, young girls shouldn't have sex. Nobody's talking to the boys at all, mind you, most of the time. But what I would like to again say is that both young girls and boys need to understand that safe sex, contraceptives to be used. There's a bouquet today that's available that children are not aware of. The age of 16 to 18, if you ask me, even 20, 25 is not, you're too young to be a child. You're hardly more than a child yourself. If you get pregnant and then you're forced to marry somebody, it ruins too many lives. This is a very complicated issue. But what I wanted to intervene with was that it was not about morality when the age of marriage was increased from 18 to 21 for girls. It was really to see that young girls who today do have much more opportunities available to them, though equality is far from, actually available, at least the girls who have a choice. What is said in most families, not just in rural areas, even in many urban areas, if 18 is the age, they just stop them studying from after 10th standard, because by that time they're about 17. If it's 21, at least young girls who say that, yes, hame college jana hai, I want to go and study, mujhe padhna hai, sort of thing, at least they get argue that, look, you anyway can't get me married till 21, let me study. And as we all know, studies do give an edge to anybody, And it is much more empowering.
So, Talishree,
as a lot of it. This is a different, this is a different issue altogether.
I get the differentiation you're trying to make. Before I wrap this debate, last comments, Talishree, then it seems to me that everyone on this panel, except a slight hesitation that that ma'am has, everyone seems to agree that the age of consent actually does need to come down to 16. And officially, if it doesn't come down to 16, you need to insert a clause that recognizes young love, that recognizes a consensual relationship. I want to ask you as an advocate, where does the Law Commission go in from here on? The recommendation has been made by the Karnataka High Court to the Law Commission of India, which means the Law Commission will now invite comments. But given the milieu that we live in, given the social milieu that we live in, will the government risk actually decrease? The point is that this will be a political decision then that is taken.
Not really. I think when the law once invites its comments, of course, it doesn't move very fast. I wish it did, but over time, gradually, these are the reflections that are brought about. And that's why we have the Law Commission, in order to aid our lawmaking to keep up with society. And that in that sense, I think, soon enough, we would see some comments. And this is not the first time that the courts have acknowledged this. In fact, there have been other cases where other courts have gone into the provision of misuse about carving out an exception that is there. So the understanding is pretty much there. It is now a question of the amount of time that it takes and when that exception would be carved out in terms of looking at consent when there are similar age people involved in a relationship that might be consensual. And looking at the understanding of consent for somebody who may be a minor under the age of 18. So I think I'm fairly confident that this is something that we will see going forward. Of course, time is something that we as lawyers really don't get into, because our notion of time and the amount of effort that it takes towards lawmaking will take its time.
Okay. Deepika Bhardwaj, do you think ultimately it will be a political decision more than anything else? Or do you think the legalese will be kept in mind and what is legally right and the practicalities on the ground, as the Karnataka High Court is pointing out, will be what will be kept in mind?
Well, Shreya, the reality actually is that the Law Commission is there, but its recommendations take, I think, eons for it to become the law. There definitely will be consultation. There definitely will be inputs that the Law Commission will receive. But when their recommendation actually turns into a law or gets, brings about change, I'm very doubtful of that, because are so many recommendations by the Law Commission, whether that is police reforms or judicial reforms or on 498A misuse, and many such recommendations that eventually did not get implemented anywhere. So I have my own reservations whether this will actually lead into anything.
Let's see whether it will, because this has now come as an official request, as it were, from a high court of this country. We'll leave it there. This was an enchanting chat. Thank you very much, Lalita Kumaramangalam, Talish Ray, Deepika Bhardwaj, and Abha Singh for joining us. Thank you all very much indeed. Will the government be given to reducing the age of consent from 18 to 16? Three of my panelists say it's high time. That needs to be done. Something called the Romeo-Juliet clause in France, that needs to be recognized and inserted into our POCSO Act as well, which recognizes the age of consent at 18 right now. It's an interesting story. We'll see how it develops. The other big story that is